is three asylum seekers, rioters, yobs who have been locked up for longer than the sex assault migrant who they were protesting against in the Bell Hotel in Epping. Dean Smith, Stuart Williams and Martin Peagram jailed for 6 years combined, were the first people to be sentenced for violent disorder outside the Bell Hotel in Essex just a few weeks ago. They were amongst around 500 furious locals who descended on the migrant housing where Ethiopian Hadush Gerberslasie was living on July the 17th. He was basically sentenced to a year last month after being found guilty at the trial of sexual assault. Let's talk to Simon now. Simon, very good morning to you.
Good morning.
I guess there will be a reason why you can tell me that these three violent protesters were locked up for longer than a man who committed sexual assault against a 14-year-old girl, but it doesn't really make any sense, does it?
Well, the reason for it, the primary reason for it, is that the three protesters who were sentenced yesterday were dealt with in the Crown Court.
Yeah.
And in the Crown Court, the maximum sentence for violent disorder is 5 years. Mr. Kebatu, he was dealt with in the Magistrates' Court. He was tried, he denied the offence and was found guilty.
Yeah.
But because he was tried in the Magistrates' Court and the magistrate who heard the case decided it wasn't serious enough to send to the Crown Court, the maximum powers of sentence that he had was 12 months, right, which is what Mr. Kebatu got. So by keeping the case in the Magistrates' Court, by definition, the maximum sentence that could be imposed was limited.
Right. And so why would he not think it was serious enough to send it up to the Crown Court?
Because any offence that can be tried either in the Magistrates' Court or the Crown Court, the Magistrates' Court has to make a decision as to which is the more appropriate court for it to be heard in.
Right.
Sexual assault.
So what's the threshold for that, though?
Well, you look at the factors. There are a number of factors. First of all, the age of the person who's sexually assaulted, the nature of the assault, whether it's overclothing, underclothing, and so forth. And then you make a decision as to the seriousness of it and which court it should be allocated to.
I mean, you might argue, or I might argue, that anybody under the age of 18 or 16, it should be considered the most serious offence, surely?
Well, obviously the age is a relevant factor. In this case, it was, as I understand it, a fleeting touch over clothing on the thigh, which would put it towards the lower end of the scale of seriousness for sexual assault. And so it's not entirely surprising from a lawyer's point of view that it was kept in the Magistrates' Court. But as I say, the consequence of that is that you are, by definition, limiting the sentence that can be imposed.
Yes, but that's why I think it's incorrect. I mean, you know, it's only my opinion, but it seems to me that if you're trying to sexually assault, and it may well be that it was considered minor, but it might have been considered minor because it didn't get to where he eventually wanted it to get. He was also trying to kiss several other younger girls as well. And I would have thought any offence involving a minor should be considered very serious.
Well, they are serious, of course, but as I say, with the way the law is at the moment, and of course it's entirely a matter for Parliament whether it wants to change it or not, sexual assault is unlike rape, for example, which has to be tried in the Crown Court, because sexual assault can cover such a wide variety of actions. The law says that it can be tried either in the Magistrates' Court or the Crown Court.
Yeah, no, I get that. What about these three men? Would they have been subject to that same kind of decision-making process? Would they have turned into a magistrate's court, or did they go straight to a Crown Court?
They'd have gone straight to the Crown Court, because violent disorder under the Public Order Act can only be dealt with in the Crown Court. Right. If they'd been charged with a fray, it could have been dealt with in the Magistrates' Court or the Crown Court, but because it was violent disorder as a result of the numbers involved, then it had to go straight to the Crown Court.
Numbers being what? You mean in terms of the numbers of people?
Yes, because for violent disorder, the offence requires the involvement of 3 or more people in the disorder, and that's the difference between a fray, which can be committed by an individual, and violent disorder, which has to be committed by more than one person.
But they weren't necessarily acting together, were they, from what I can see?
Well, They must have been, because they pleaded guilty, as I understand it, and violent disorder is 3 or more whose actions taken together
But again,
put people in fear of violence.
But again, you know, definitions are important, aren't they? You know, as you say, sexual assault can carry a variety of different seriousness depending on how serious it was, in the same way that this could have been a fray, but somebody decided it wasn't a fray, somebody decided it was violent disorder. They might not have understood the difference, and they might have pleaded guilty because they were advised to, because they might have got lesser sentences. But it does seem perverse, I think, to a lot of people listening, that, you know, the three men who are, you know, are found guilty of attacking police officers somehow end up in prison for longer than a man who tried to sexually assault a 14-year-old girl.
Well, they're completely different offences.
No, I understand that, but you understand my point, don't you?
I understand it entirely. But as far as the three who were sentenced yesterday are concerned, as I say, they pleaded guilty. I wasn't in the case, but I assume they were advised properly by their solicitors and barristers as to whether they were.
That's an interesting assumption, because people who generally are not averse, are not sort of equipped to understand the law, will often do what is suggested to them, because they don't know really any other choice.
Well, that's right, and that's why you have a lawyer advising. But if I'm advising a client, I don't advise them to plead guilty unless, on the instructions they give me, I am satisfied that that is a proper plea for them to enter.
Right.
And
but
if somebody
it doesn't appear as though they've got a break for pleading guilty, does it? I mean, presumably their sentences are towards the heavier end of sentencing for that particular offence. Well,
as I say, the maximum sentence for violent order is 5 years. There are guidelines from the Sentencing Council, and it's interesting that Robert Jenrick has just announced that he's planning on scrapping it. And when you look at the Sentencing Council guidelines, this falls pretty much in the middle of the area of seriousness as between culpability and harm. And so the starting point is set at 3 years.
Right.
The judge who passed sentence yesterday has gone down from that, presumably to reflect the fact that they did plead guilty.
Well, also presumably because he didn't think it was that serious.
Well, that too.
Yeah.
Yes, I mean, he'll have weighed up.
So he weighs up that what they did wasn't that serious, and we get another judge in Magistrates Court saying that what the sexual assaulter did wasn't that serious, but they still end up getting more than he did.
Well, I come back to the point I made earlier, that the magistrate in the Kebatu case passed the maximum sentence that was available to him.
Yeah.
So he obviously took the view that of the type of sexual offences that are capable of being dealt with in the magistrate's court, it was the most serious of its type.
Yeah, some might say serious enough to bump up to the Crown Court, but we could do this all day. It's like a moot, it's like one of those moots that we used to do when I was studying A-level law. There we are. Listen, good to talk to you, Simon. Thank you very much indeed, Simon Spence there. I mean, you see the problem with the law, because it's riddled with what Simon very well explained there, with choices, and choices get made based upon individual personal opinions. The judge in the Magistrates Court decided that, attempting to sexually assault or sexually assaulting a 14-year-old girl was not a serious enough offence to bump it up to the Crown Court, where he would have got a much longer sentence. Surely it should be written down for these people to say any kind of sexual assault involving any kind of minor under the age of 16, certainly, if not 18, should become serious enough to automatically go to the Crown Court, surely, to heavens. And then they can sentence them properly.